Has everyone had an opportunity to review that report?
Yes, Your Honor.
I have. I've also received, it looks like a letter from Mr. McGee that I have taken notice of, as well as a couple of, looks like some incident reports from the jail. Have you all had an opportunity to review those?
Yes, Your Honor.
I have. Are there any additions or corrections to that pre-sentence report?
Your Honor, the only additions that I would have is that I've received 2 letters from family members. I'd like to have the court have access to that before making a decision. However, I'd like to read from some of the letters as part of my closing. So I'd like to hold on to them, but then I would like to present them to the court. Okay.
Hold on, this is a major courtroom moment. The defendant has already entered a guilty plea and now he's asking to take it back. Legally, that's much harder than many people think. Once a judge believes a plea was made knowingly and voluntarily, withdrawing it usually requires a strong legal reason, not simply changing your mind after learning more about the possible sentence. Watch closely because the judge's next response could shape everything that follows.
By 2 close family members. And then further, the only other correction in the pre-sentence report, I guess we need clarification. While the defendant was previously in court and pled guilty, he's informed me this morning that he wishes to withdraw his plea. I let him know that that was up to the court. That's not up to me.
So, Mr. McGee, when you were here before, you were sworn in by the clerk and asked you some very specific questions about your plea and whether or not you were doing it freely and voluntarily, whether or not you did it because you actually did what they charged you with. Obviously, you know that I sat through the trial of your brother, so I've seen all of the evidence against you that would be presented at trial.
This is an important legal clarification. The judge just corrected misinformation that the defendant reportedly received in jail. Probation is still legally on the table, but that doesn't mean it's likely. Eligibility simply gives the court the authority to consider it. Whether it's actually granted depends on the facts of the case, the defendant's conduct, and the judge's assessment of justice.
Trial, the videos, all of the things. And so I guess I'm not inclined to let you withdraw your plea. I want to know, though, quickly why you think you want to.
I don't want to withdraw my plea because I was informed. Well, I found out that I can't get probation on this, and I thought I could.
And that's not correct, Your Honor. He is eligible for probation.
You are eligible for probation.
Affirmative
finding of a weapon, I couldn't get it.
What?
Affirmative finding of a weapon, I couldn't get it.
If I make that finding, I can give you anything right now from a deferred probation up to 30 years in prison. That's the range of punishment. So you are eligible for probation. That is an option that I have. So that's whoever has told you that, you're misinformed. That is an option. All right. So I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
Thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence, but the one thing that I think needs to go in Mr. McGee's favor, obviously, is that he did take responsibility. He did plead. Obviously, he's gotten some bad.
Now the defense shifts into mitigation. Difficult childhood abuse, family loss, newfound faith, and becoming a father. These are all factors courts may consider during sentencing, but hey, raise the critical question: how much weight should personal hardship carry when the crime itself is extremely serious? That's one of the toughest balancing acts any sentencing judge faces.
Legal information in the jail since we were last here in court, but that shouldn't change the fact that Mr. McGee has had no criminal history other than some traffic citations and a few failures to appear on those traffic citations before this. He's never been in our system. He's never been on probation before, never been sentenced to prison before because he has no criminal history. Mr. McGee did not live the same life that many of us have lived. One of the letters that I received from a close friend, they've known Devin since 2017, so approximately 6 years. Not only did they speak very highly about how Devin would typically put himself before others, and he had a very rough childhood, his mother passed away in front of him at the age of 27. They had no father figure. They were tossed and moved around with their 3 aunts from 2007 to 2017. They both suffered physical, mental, and verbal abuse from 2 of their aunts. Mr. McGee also has a 3-year-old child. He's never really stood much of a chance. He's never had a positive male figure in his life, and that's not my words. Those are the words of close friends and family members that have kind of...
While this may be the defining moment of the hearing, instead of accepting the apology, the judge interrupts because the apology appears to minimize responsibility. In sentencing, judges often look for genuine accountability. If they believe a defendant is shifting blame or rewriting what happened, it can significantly affect how credible that remorse appears.
On his behalf. They were completely shocked and said that this was out of character for him to partake in this crime. They believed that he was following his brother. They said that this is not who Devin is. Obviously, the court has just what it has in front of them, which is the evidence from that case. And if you just look at the evidence in that case, obviously it's going to give you pause because of the nature of and the violence that took place in the offense. While my client understands the law of parties and he knows that he's just as responsible for whatever his brother did that day, I will say that he was not the aggressor or the main aggressor in the situation. The crime that they committed was despicable, and he would agree with that. He thought that he was going over there to retrieve stolen property. He did not know that his brother was going to start shooting. And in visiting with Mr. McGee, I believe he was also a little afraid and didn't know what to do in the situation once it started going further and beyond what he thought it was going to be. Further, Mr. McGee has told me that he has found...
Hey Race, what makes this case especially compelling? The judge repeatedly points to the video evidence. Unlike many criminal cases that rely heavily on witness testimony, this courtroom has footage showing the events as they unfolded that gives the court a direct way to compare the defendant's statements against what was actually recorded.
Religion, he has, one of his write-ups has been because they did not warn the jailer when they were going to pray. So that was one of the write-ups that he had. He also had a jumper malfunction with his buttons. But he says that his newfound religion has given him discipline and peace in his life. He has a son now. He apparently did not know about that. I believe he became aware of that while he was incarcerated. The child is 3 years old. And he would like to have some sort of a life with a son. I would suggest that he get 10 years deferred adjudication probation, and if he messes up even one iota, he's got the full range to deal with. So I would suggest that he get 10 years deferred probation, be put on intensive supervision, 0 tolerance, and actually be given a chance, because based on his criminal history, this is not who he is. This is not... And I hope the court doesn't take into account the fact that he tried to withdraw his plea today. I think he got some bad information.
No, I'm not worried about that.
Yeah, he got some bad information in the jail, but he is eligible for probation. I would ask that he get probation, and I'd give Mr. McGee a chance to address the court and explain why he...
Cases like this remind us why sentencing is rarely black and white. Courts must weigh accountability, rehabilitation, public safety, and the lasting impact on victims all at the same time. That's what makes these hearings so challenging, and why reasonable people can sometimes disagree on what justice should look like. What would your decision have been if you were the judge?